All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Thank you. We are here today in our case 1 CV 150188 is BARNET versus Medical Management Resources Group. There was a motion to extend the argument, which we have done. So each side will have 30 minutes for argument. Because we've extended the time of that, the time that we have that we've allowed. So that's all that council are going to get today. You'll be able to keep time with the clock on the podium. If you want to reserve time for rebuttal, you're entitled to do that, but you'll have to keep track of the time on your own. We are recording the argument on YouTube, so in a few days you'll be able to watch the argument if you choose. We have conferenced the case. We've read the briefs and discussed the issue, so we're familiar with the case and the argument. So when you come up to speak, just launch right into your argument. And because we're recording this, please identify yourself and your client when you begin your argument. Counsel?
Good morning, Your Honors. My name is Joe Schenk. I represent the appellant in this case, Ronald Barnett, and we are before you on appeal from a summary judgment entered against Dr. Barnett on all counts of his third amended complaint. The overriding issue I think the court has to consider is whether or not the appellees in this case can, through a series of corporate manipulations and name changes, effectively conceal and insulate themselves from financial responsibility for what was essentially the theft of Dr. Barnett's retirement income.
Counsel, whatever happens with the corporate forms, there are still direct claims against the various doctors, correct?
That is correct. And in fact, I would argue that given the unusual circumstances, that there are direct claims against BDPEC as well. Because even though they would argue that the conversion of the surgery center facility fee business to themselves harmed only Phoenix Healthcare Group, PHG, the fact of the matter is that the harm and damage was suffered solely by Dr. Barnett, and therefore it was a direct sort of injury that under Edelson and some of the exceptions that have been recognized, the Fink case as well, he would have had a right to bring these in his individual capacity. And I think that...
But he didn't, right?
Well, he brought them derivatively, and I believe that he did so properly, but they are claims that he could have, I believe, brought individually as well. So
how does that help us here?
Well, I think it helps in the sense that because he asserted the claims derivatively, if the derivative portion is excluded, he still brought the claims. And so if he doesn't have capacity...
Well, but he brought the claims on behalf of PHG. He didn't, at least as I understand the record, correct me if I'm wrong, but he brought the claims on behalf of PHG. He didn't bring them, at least he didn't bring certain claims on behalf of himself.
Well, actually, if you look at the 30-minute complaint, there are 7 counts. And count 1 was declaratory relief that he brought on behalf of PHG. Count 2 is breach of fiduciary duty against the individual appellees, Rosenberg and Perkins, which he brought directly. Count 3, breach of fiduciary duty against BDPEC. I believe he did bring that derivatively. Bad faith against Rosenberg and Perkins was on behalf of Dr. Barnett individually. Count 5, promissory estoppel against Rosenberg and Perkins was by Dr. Barnett individually. Count 6, civil conspiracy against Rosenberg and Perkins, again, was by Dr. Barnett individually. And count 7 was aiding and abetting against MMRG, BDPEC, Rosenberg, and Perkins. And again, if you look at the complaint, he brought that individually. So the bulk of the claims are brought individually. But the focus has been, I think, specifically on the breach of fiduciary duty count against BDPEC, which was brought derivatively. So, again, a lot of these claims, it is relevant because he brought them, if you go back and look at the 30-minute complaint, he brought them in his own name, not solely as a representative of PHG. So I think that's why it matters. The court's question, though, leads me to want to, I guess, digress and talk a little bit about the whole issue of whether or not Dr. Barnett did all that he needed to do in order to file a derivative action on behalf of PHG in this case. And we would submit that he, in fact, did, because in December of 2011, before filing the original complaint in this case, he sent a lengthy and detailed letter to appellees Rosenberg and Perkins, through their attorney, because they were then represented by counsel, outlining a variety of reasons why he believed that the claim by MMRG that it was entitled to receive additional management fees was not a valid claim against the surgery center, and insisted that they take action on behalf of PHG to prevent it from authorizing the payment of those fees. And so that letter, and that letter specifically referenced that if they refused or failed to do so, that Dr. Barnett would pursue a derivative action on behalf of PHG on his own.
I have a couple of questions about that. PHG is confusing. PHG is a manager of the surgery center.
PHG is a 51% owner of the surgery center.
Right. So,
isn't it also the manager?
No, it is a manager. There are 2 managers. If you look at the operating agreement for the surgery center, which I think we attached as in our appendix,
It's
I think
CHG and
BDPEC.
yeah.
PHG owned a 51% membership interest. BDPEC owned a 49% membership interest in the surgery center. They were both managers. But because PHG had the 51% interest, it could have blocked the voluntary payment of money by the surgery center to MMRG, which, not coincidentally, is a 90% owned subsidiary of BDPEC.
well, counsel, one of my questions, though, is the claim itself is between surgery center and MMRG. So PHG, to the extent that it could have done anything, it would have had to have filed a derivative action itself on behalf of Surgery Center against MMRG. And I don't see that I mean, first, I don't see how that was asked for in the demand letter, and then the other question is, how do you get by standing? Because your client is at least two steps removed from the dispute between Surgery Center and MMRG.
Well, there's actually two questions. Let me take them individually.
Sure.
The first one is PHG was the only would be the only harmed party.
They were harmed only because their income from Surgery Center would be reduced, and the harm in the dispute seems to me to be between Surgery Center and MMRG.
Surgery Center was a pass-through entity. It operated the surgery centers. It paid 49% of its profits to BDPEC. It paid 51% to PHG. BDPEC, by having its subsidiary claim these additional fees, was in essence saying, even though we're only entitled to 49% of the profits, we're going to take more for ourselves under what we claim was a completely bogus claim for additional management fees. And PHG, so BDPEC is not going to be harmed by that because they're getting the money. They're actually benefiting from the theft. This is a situation, the easiest way to look at it, the situation is you have a company that's owned by two owners. One owner goes into the company's bank account and steals money and puts it in his own account. Now, that other member, the one who didn't steal the money, he's the only one that's harmed because the bad actor got the money. The only non-bad actor.
These aren't bank accounts. These are entities, and they're entities that your client obviously took great care to set up in as convoluted a fashion, I think, as I can imagine on the diagram I have. At this point, why should we disregard the formality of that organization?
Well, first of all, you don't have to. As I said, this is a classic issue. You got cases out there that make it clear that if you got a two-owner company and one owner is stealing from the company for himself, that's the Fink v. Spalding case.
Well, but now we're talking. Let's stay on the claim we were talking about, because what you're arguing is that there was wrongdoing here and there must be a claim. Understood, but when we talk about the specific claims and the way they were pled, the only way we get past the standing problem that I can see, and I think you alluded to this in your comment, is to ignore the corporate formalities and say, oh, this was just a pass-through entity. We don't have to regard it as a separate entity. That puts us on a dangerous legal slope, doesn't it?
I don't believe so. Again, I call back to I think it was a Supreme Court decision, Fink v. Spalding, which basically addressed this sort of situation where it is a two-person company and one person is stealing from the company to themselves. It's not the company that's harmed.
Did that case involve multiple levels of organizations as this does?
It didn't, but we're only focusing on the first level because what we're talking about right now was PHG harmed. We can get to the next level, and I'm happy to get to the next level, but the first level is you were saying the only one that was really, could bring this would be the surgery center, and no, the surgery center couldn't bring it because it was controlled by two management companies, one which was BDPEC. BDPEC says basically through our subsidiary, we're going to take money out of the company. Now, you would expect...
So PHG would then have to bring a derivative action on behalf of Surgery Center.
No, they could have. They wouldn't have had to bring an action at all. All they would have to do is say, we got a 51% ownership interest. We don't approve the payment of this money. And then it would be an outright theft. PHG could have prevented the payment of money by the surgery center to MMRG, which again is a BDPE subsidiary. All it would have had to do is if we'd had honest management treating its members fairly at PHG, they could have said, no, we have the controlling 51% interest in the surgery center, and MMRG, we're not going to allow the surgery center to pay your claim.
There's some logic to that, but then you don't even need a derivative action, right? You
That's-
Barnett sues PHG and we're done.
Well, and he has sued PHG.
Okay, and I'm not talking globally about all your claims here, but I am trying to separate them because we have to. And the derivative claim seems problematic for that reason. If the demand was really telling PHG, we don't want you to sue, we want you to vote, and they don't vote, then I suppose
And go back and look at the letter. That's what we're saying is do not pay this claim. You have all these valid reasons to not allow the surgery center to pay this claim. And if you don't take some action to prevent the surgery center from paying this claim, then we're going to file a derivative action to prevent it. And if you look at it, the original complaint was basically a declaratory relief claim. That's still count one of the third amended complaint, was a declaration from the court that the payment of these management fees was inappropriate and was not a valid claim that should have been paid.
Counsel, as I understand derivative lawsuits and demand letters, a demand letter is not a general complaint that here's the problem, I want you to fix it, here's how I want you to fix it. As I understand the demand letter is, I believe that the entity that we're dealing with has been harmed. I want the management of that company to sue the entity causing the harm, and if the management doesn't do it, then I, as a part owner, on behalf of the entity, is going to sue. So I don't understand how a letter asking them to vote a certain way to prevent the disbursement of funds then constitutes a demand letter under the statute.
Well, here's the situation. We've got Applebee's, Rosenberg, and Perkins controlling both sides of the transaction. You've got them controlling MMRG and BDPEC, and they also have maneuvered themselves into being two of the three managers for PHG. So they basically can enter into whatever kind of collusive agreement that they are inclined to do.
Are you now shifting to the direct claim against Perkins and Rosenberg?
No, but I am saying that this is not your typical situation where you have arm's length people, and this is a classic case of self-dealing where, for purely punitive reasons, Applebee's, Rosenberg, and Perkins decided that they were going to strip money away from Dr. Barnett. And it was strictly against Dr. Barnett because Rosenberg and Perkins both had, well, Mark Rosenberg owned a 10% interest in PHG, but he also owned a 10% interest in MMRG. So every dollar that was taken away from PHG and given to MMRG was a wash for him. He got the same money. Dr. Perkins had a 9% interest in PHG, and he had a 10% interest in BDPEC, which in turn had a 90% interest in MMRG. So every dollar that left PHG and went to MMRG ended up being a dollar that he got on that side of the deal as well. So it was a wash transaction for both of them. Dr. Delaney, who was the only other significant interest holder in PHG, was basically bought off, and BDPEC paid him monthly payments in order to buy his interest in PHG.
I have no doubt that there are people on both sides of the transactions, but as our court said, or recognized in Rose, there is no futility doctrine here, and I have no doubt that a demand letter under these circumstances would not have succeeded. but that doesn't mean that your client doesn't have to do what the law requires him to do. And my reading of the letter and then the response, the demand letter only pertains to count one, which is the declaratory judgment action.
Exactly. And let me tell you why I think, and that's actually, I think, the most interesting part, and we covered it more fully in our reply brief, but this is a case of first impression in Arizona. And it is not the Rose NBA property situation, because here you did have a timely and appropriate pre-suit demand by Dr. Barnett that satisfied all of the elements of ARS Section 29831. I don't have time to go through all of them, but it did satisfy them. When they came back and said, we don't think that it's in our best interest to challenge the taking of this money by MMRG, when the other two managers of PHG, Rosenberg and Perkins, came back and said, we don't think it's a good idea, that was basically a rejection of our demand, because it was essentially a counteroffer, because they made some settlement proposals. And at that point, we had done all we had to do in order to file that initial complaint based on the scope of what had happened as of the date the complaint was filed. What you have here is an unusual situation. And the analogy I would give you is that a director of the company takes $10,000 out of the company's bank account and puts it in his own. One of the shareholders demands that the company pursue that $10,000, and the company says no, so he files a demand and files a derivative claim against the person who stole the $10,000 out of the company's account. After he does that, after he files the lawsuit and it's going on, the same executive reaches into the account and takes another $10,000 out. Now, the question is, having made a pre-suit demand, don't steal money from the surgery center, and filed an initial derivative action saying, I am going to pursue your taking this money from the surgery center, they took more money away from the surgery center. In fact, by September 2012, they'd taken all of the money away from PHG and the surgery center. And so, all those things were facts that occurred subsequent to the filing of this derivative lawsuit. So the issue here is, if you have done all of the proper prerequisites to filing a derivative case, and then the bad actors continue to engage in a course of the same type of bad conduct after the lawsuit is filed, do you have to file another pre-suit demand and a second lawsuit?
Well, that is the issue, and I think I understand what you're trying to say, but tell me, have I missed something? And I may have. Was there a direct claim by Barnett against PHG for failing to cast what Barnett believed was the right vote on the payment issue?
No, because he was suing on behalf of PHG on the initial derivative case, so it would have been a little awkward for him to be in the same lawsuit suing as a representative of PHG on the plaintiff's side and naming PHG on the defense side. But he did sue the two PHG managers for their wrongful conduct in basically...
And we haven't even focused on that yet, but based on your earlier argument, if PHG is a 51% owner of Surgery Center and PHG can stop the payments just by voting no, isn't the logical lawsuit, the simplest, most direct lawsuit, won by Barnett against PHG without all this derivative business?
As I say, he has those claims, and we haven't talked about them, but at the time, it was pretty clear that the money was being taken not directly by Appley's, Rosenberg, and Perkins, but was instead being funneled to BDPEC.
But PHG, in theory, I mean, I understand this is all collusive, but PHG could have stopped it all just by saying no.
If the managers,
And
if the managers of PSG would have done their duties, yes.
Right. But PHG could have stopped it by saying no and waited for the inevitable lawsuit against it by MMRG.
That would have been fantastic. But it didn't happen that way.
But there was no claim saying that it should have happened that way, is my point.
Well, as I say, it was an evolving situation because at the time this lawsuit was first filed, there was, in fact, no payments had actually been made by the surgery center to MMRG, and the action was initially filed as one for declaratory relief on behalf of PHG, saying that these are not valid claims by MMRG. After that, they got worse and worse because they then went into this collusive settlement where they basically tried to block that initial derivative action by saying, well, Rosenberg and Perkins, on behalf of PSG, are going to vote to authorize a settlement between the surgery center and MMRG, where the surgery center waives all of its claims against MMRG in exchange for a 23% reduction in fees that were never owed. And when you consider that the whole claim of the fees was based on a management services agreement that the surgery center never even signed, was never a party to, it was a bogus claim to begin with. So they were settling a bogus claim.
Well, the surgery center never signed it, but who did it purport to? Between whom did it purport to be?
It purported to be between MMRG and, I would say, a company called BARNET Delaney Surgery Center LLC, which was a Delaware.
Well, you would say. I mean, what does it say on the document?
It says that. It says that. But the problem is, at the time the agreement was signed, the only company doing business under the name BARNET Delaney Surgery Center was a Delaware company. The company that is now doing business as the BARNET Delaney Surgery Center, at the time this document was signed and for more than a year afterwards, was doing business as the BARNET Delaney Perkins Eye Center PLLC. They've switched the names around, and I put charts in my, I think it's Exhibit 2 or whatever, to our appendix, or Appendix B, the second document, just to show you, because they basically would take and give the same name to different entities at different times. So when you're looking at who signed the contract, you have to look at when the contract was signed to see what is the actual entity that was a party to it. And it's like a shell game where they're moving the same name around to multiple entities. So if you don't follow that timeline that we had to construct during the course of the litigation, you'll never know who was actually claiming to be bound under an agreement. I'd like to reserve what I have left because I'm down to 4:45.
Thank you, counsel. Counsel?
Thank you. Good morning, judges. I am Nicole Goodwin on behalf of the Greenberg Traurig Law Firm. With me today is my colleague, Netta Gales, and we represent what we've referred to as the entity defendants, which are the acronyms BDPEC, BDSC, and MMRG. I know I don't have a lot of time, and I do want to respond to some of the issues that Mr. Schenk has stated on the record. To make it very clear, at no time has Dr. Barnett sued PHG. That is not a component of the complaint. The complaint is very clear that all of the claims against my clients, the entities who I represent, are derivative in nature. They are not direct claims. And we brought 3 separate motions for summary of judgment, all of which were granted by the trial court. And we urge this panel to affirm those grants of summary judgment. The first one that I'd like to discuss is the one that dismisses all of the claims on the basis of a failure to comply with Arizona's derivative claim statute. And what Mr. Schenk is urging this court to do is disregard it, essentially, as it pertains to the surgery center takeover, what he refers to as the takeover of the surgery center premises, and say, well, it's okay because you already had an action in place. You essentially have a free pass to bring any other grievances you may have with respect to this entity, so long as you are a plaintiff. And that is not the law, and that's not what Rose Goodyear says, because Rose Goodyear makes it very clear that it is a prerequisite to filing suit that you are very specific about what you want the company to do, or what you want the people you're making the demand to do. And Mr. Schenk and Mr. Barnett never did that, and we brought that to their attention throughout the course of this litigation in motions to dismiss. I mean, it's a failure that has been very blatantly apparent for many, many years, and here we are in 2017 talking about this very failure.
As I read the letters, it seems like the demand letter pertains only to count one and not to anything else. Is that correct?
That's correct. And it could only, at that point in time, pertain to count one, because the events that are complained of in counts 3 and count 6 and count 7 hadn't occurred yet. So just by its very nature, when the letter was sent in 2011, it was only complaining about the management services fees dispute, which was the component of count 1. And there are certain parts of the record that I think bear emphasis here, which is the management services agreement that Mr. Barnett, or Dr. Barnett, is now challenging was a document he signed. These entities that are at issue, I know, Judge Swan, you referred to them as perhaps convoluted or complex in the way that they were structured. It was Dr. Barnett who was in management of these entities during all of the relevant times when they were structured. So now, fast forward to when feels like he's odd man out because he's no longer a member of the medical practice. He's lost his license. He's no longer performing procedures. His legacy interest is his membership interest in PHG. That's all he's got. But these documents mean something. They were agreed to by sophisticated people, and they convey certain duties and obligations and rights. And one of the rights that Dr. Barnett has is to act as one of the 3 managers of PHG. And he did that. But he is one voice out of 3, and the other 2, as demonstrated by the record, disagreed with his position. And that gave rise to the settlement agreement that took place between the surgery center and MMRG, and that issue was resolved. And of course, it's good public policy that when entities with due authority enter into agreements, that those agreements not be disturbed. Because otherwise, you have a situation like we have here. Many years later, even though these parties with authority have resolved a dispute, you have an outsider complaining about it and wanting to restore funds to Barnett.
Was there any real dispute to resolve, though? I mean, I do respect the corporate formalities, but how real a dispute was this?
So I will tell
who was on which side of the table?
Sure, I will tell you, Your Honor. And this is in my experience, this is not unheard of to have a management services company that provides services. And in this case, MMRG provided services to both the surgery center and also to Barnett Delaney Perkins Eye Center, BDPEC, which was the medical practice. And it had 2 separate management services agreements, which were essentially mirror images of one another because they were prepared at the same time by the same counsel. So what those agreements provide is that MMRG will provide billing functions and other administrative things. And you saw the agreement. So there is no dispute in the record that those services were not actually provided and faithfully provided, and they were provided.
But my question is whether there was a dispute to settle. If Dr. Barnett had never been born, mm-hmm. who stands to win or lose from various resolutions of this so-called dispute?
I see, Your Honor. If Dr. Barnett was not raising a fuss about this, I mean, perhaps 100 cents on the dollar would have been paid. The agreement would have been complied with in full.
No, let's say Dr. Barnett was not even part of the deal.
Mm-hmm.
If everything in this structure were exactly as it is, except Dr. Barnett was never there,
mm-hmm.
whether 0 is paid or 100% is paid, does any human being actually care?
Yes.
Who?
And, it's because there are different ownership interests with respect to different entities. So Barnett Delaney Perkins Eye Center is a very busy and successful medical practice. It has members who are different from the members of PHG. PHG, we can think of it as a preferred group or more of a legacy group, has separate ownership.
But it has separate ownership, but common management, doesn't it?
Certain members of management on the PHG side. Dr. Perkins, for example, is a manager of PHG, and he's also a manager of BDPEC, but he is not the only one by any stretch. And my colleague, and I should have made this clear early on, I'm splitting my time with my co-counsel, Bob Mann, who will be speaking on behalf of the individual defendants, and he would be able to answer those questions about who else is a component of the decision-making that you're referring to, but it's not identical by any stretch.
The decision-making component is not, there are people involved in one entity who have absolutely no financial interest in the other.
Yes.
Okay.
They absolutely. And no interest in the distributions. And I want to make that point because that's something I think Judge Howe was referring to when we were talking about these like strata of the entities. So Mr. Schenck and Dr. Barnett like to talk about money, funds, like this is just like money that's being stolen and, put into the Brinks truck. And, that's not what happens the way these entities are conceived of. There is a surgery center that receives revenue from facility fee income. So you have a doctor who's employed by Barnett Delaney Perkins Eye Center. Say it's a cataract surgeon. He or she is performing a procedure over at the surgery center. That professional will receive fees for his or her own time, plus there will be a facility fee that will be earned by the surgery center. In turn, the surgery center pays its expenses, whatever those are, and then the remaining money is subject to distributions. And the Barnett Delaney Surgery Center operating agreement provides for how that is done. So those distributions flow two ways, to BDPEC, which is the medical practice, which owns 49% of the surgery center, and then 51% of the available money for distribution goes to PHG. And then when you take it a layer down, we have the members of PHG. And at the time, Dr. Barnett was a 38.25% interest holder of PHG. So it's not like there's money that has PHG's name on it, and that's what Dr. Barnett is trying to get back. Instead, it's the income that the surgery center receives by virtue of the business it conducts, which then, after paying expenses and dealing with its management fees and whatever else it might be subject to, it has monies available for distribution that then flow out.
Well, but counsel, as I understand it, though, is if the other managers of PHG who were managers or had interests in the other entities, if they decided that they wanted to arrange things so that Dr. Barnett would be starved of funds, they could do that, but they themselves wouldn't be harmed because the money that they're losing on the PHG side, they're making up on the accident side of the MMRG side.
Right.
So there is no dispute really as to the other people other than Dr. Barnett.
Okay.
Is that correct?
No, Your Honor. Respectfully, it's not. And that is the oversimplification that Dr. Barnett has attempted to make by using the Mr. Rosenberg example. He talks about, well, Mr. Rosenberg has 10% here and 10% here, and it's a wash. Well, that may be true, but there are other interest holders in PHG. For example, Dr. Delaney, who was one of the founders of the practice, also had an interest in PHG, but was no longer and could no longer be a member of BDPEC because he was no longer a practicing physician, so he couldn't be a member of the PLLC. So his interests are disparate. You also have many other members of the medical practice who aren't interest holders in PHG, so there is not an identity. It is a vast oversimplification. And the key point, and this is something that has never been disputed by Dr. Barnett in the record, is that the doctors of BDPEC made it very clear that they were no longer going to voluntarily, and that is very important because it only was a matter of their volition. They were no longer going to voluntarily perform procedures in any center in which Dr. Barnett held an interest. And that was because Dr. Barnett was at complete odds with them. He had sued the doctors several times. He sued to get his name back from the entities. Here you have a going concern that's known as Barnett Delaney Perkins Eye Center. He wanted his name back after retirement. He was trespassing on the premises. All of this is in the record and is unrefuted, that there were very good reasons why these doctors who have the complete choice to perform procedures wherever they please did not want to voluntarily benefit him any longer. So when you hear Dr. Barnett or his counsel talking about retirement and all these things like that sound very solid and secure, the nature of this whole operation depended on Dr. Barnett preserving the goodwill of the doctors. Because if he didn't have the goodwill of the doctors, he can't force them. It's legally improper. He couldn't do it. There's no contract that can require it. He can't force them to use his center or the center in which he, indirectly owns a piece. And that's where all of this falls apart, is because Dr. Barnett, because he looks at this like bags of money, because that's all it was. He sat back and collected checks. He looks at this as he's been aggrieved. But when you look at the structure and the documents, with respect, he's missed the point. He, through his own actions, has upset this apple cart and caused these doctors to make the decision, which they're free to do, to not patronize his center any longer. So that brings us to, well, how did BDPEC act when faced with this reality, right? So the doctor said, well, we're not going to patronize the center any longer. So BDPEC, and this is again undisputed on the record, took certain acts to preserve the surgery center's interests. For example, it purchased the equipment that the surgery center would have had no use for any longer. MMRG, which is the service company, commissioned a third-party arm's length appraisal and had that done and paid fair market value for every scalpel, gauze, every piece of equipment that was part of the surgery center. There was more than 60 days notice provided to the surgery center to allow continuing, patient care and allow it to vacate the premises. So under the circumstances, there is no evidence in the record that disputes that what happened once that decision was made was done very fairly to the surgery center. Because without having the doctors choosing to use it, there would be no revenue stream. And that's where there's a disconnect, and there has been for quite some time between the entity defendants and Dr. Barnett. So I know that only addresses the derivative piece, which if the panel affirms what the trial court did, that means that all of the claims against my clients go away, with the potential exception of count 1, which is the one that depends on the that December 2011 demand. And we believe there are other reasons why that demand was insufficient. They're in the briefing. I don't want to spend a lot of time on them here, and they have to do with the fairness and adequacy of Dr. Barnett as a representative and whether it was improperly refused. But the key point is that even when the other claims, even if count 1 were to remain because on the derivative grounds alone, it fails because there is no standing on the part of PHG to complain about the management services dispute beyond what it did, which is place a vote, or to try to invalidate the settlement agreement. Those claims, the way they have been pleaded, would belong solely to the surgery center and not to PHG. So the trial court properly dismissed that claim and entered summary judgment in favor of the entity defendants. The final motion that I wanted to discuss was when the court granted our motion for summary judgment on the breach of fiduciary duty claim that Dr. Barnett asserted against BDP. And that decision was appropriate because Dr. Barnett has conflated what duties apply. He has stated that he believes that because PHG and BDPEC were parties to an operating agreement as part of their ownership of BDSC, the surgery center, that they owed each other, or that BDPEC owed PHG an obligation not to do anything that would harm it, essentially, to put its PHG's interests ahead of BDPEC's own. And since Arizona has adopted RUPA post-1996, the standard for what fiduciary duties apply in a partnership context, which is what the parties agreed to by contract here, is nowhere near that standard. So the duty that applies, which is if you act in self-interest to do it fairly and that sort of thing, has certainly been met. There's been no breach. And an issue that Dr. Barnett has never squarely addressed is that the parties to this arrangement have ratified the conduct. So to the extent there was a breach, which is disputed, it's been ratified. And Arizona law provides that the members and the managers of entities could certainly, if they so desire, ratify conduct that might otherwise constitute a breach of fiduciary duty. With that, I will turn it over to Mr. Mann.
Thank you, counsel.
May it please the court, Robert Mann on behalf of what have been termed the individual defendants, Mark Rosenberg and Dr. Scott Perkins. And the way I guess I'd like to begin the conversation is with the derivative claims and the derivative demand statute and how it applies to what are really the two general sets of allegations. One of the sets of allegations being that there was this settlement that was wrongful, of course, and then the other set of allegations is that Perkins and Rosenberg had something to do with BDPEC's decision to retake the surgery centers. Not just
that occurred after the original demand letter, correct?
Right. There was no demand that Scott Perkins and Mark Rosenberg cause PHG to sue in its own right to do anything with regard to BDPEC retaking the surgical centers. So in terms of applying those issues to the demand requirement, there was never a demand, there was never a refusal. So that part of it's a short discussion. Where I want to begin is with the elements of three of the elements of a demand, because I don't think they were ever met here, and this is a due care, breach of due care lawsuit, and so it's going to be a derivative lawsuit because it affects all of the members of PHG the same. There's a Dr. Pinkert who's also a member of PHG. Delaney was a member of PHG before his passing, and then of course the three managers that we've talked about. And under the statute 29831, of course, there must be a demand that by Barnett that Rosenberg and Perkins cause PHG to sue in its own right. So let's just start with that before, and then I'm going to talk about the refusal, whether there was a refusal and whether such a refusal could be coined as wrongful. So the demand came from the December 1 letter, December 1, 2011 letter on behalf of Barnett to Rosenberg and Perkins. And there was a demand initially in that letter. There were multiple demands. It actually reads more like kind of a settlement negotiation letter. But the demands were on the last page of the 5-page letter. And there's a demand, for example, that the managers of PHG act to protect PHG's interest. Okay, that does not satisfy the statute in Arizona, of course. Then enumerated as number 1, PHG should prevent the surgery center from voluntarily remitting payment to MMRG. That is still not a proper demand under the Arizona statute because it is not a demand that Rosenberg and Perkins cause PHG to sue in its own right. Moreover, there's been this discussion, and early on in the letters that went back and forth, there was a consideration whether PHG, as a 51% owner of Surgery Center, could stop payments. So under this Section 1, the Surgery Center operating agreement provides that it's managed by its managers. There's 2 managers. So that both managers would have had to agree to stop making those payments. Just because PHG owns 51% of it, each manager gets 1 vote. So
And what happens in the case of a tie?
Yes.
whatever happens in a case of a tie, there's statutes to dissolve it. There's, if it causes the entire entity to break down, then that's that.
Under these organizational documents, if the ownership had been 99% and 1%, the 1% could deadlock?
Sure, if you have, it's the same thing with PHG. There's 3 managers of PHG, and they vote, and 2-1 carries it, 3-0 carries it, obviously. And so when you have 2 managers and you have a LLC that's manager managed, you got 2 votes.
Even though one manager has a greater interest than the other manager.
Sure, Dr. Barnett has the largest ownership interest in PHG, but he has 1 vote as a manager. And that's why we're here, because he's not voting his ownership interest. There are clauses in various of the LLC agreements that say if you're going to remove or add a manager, you vote your, it might be that you vote your ownership interest. But on these issues that we're talking about, the managers manage it, so they get 1 vote. And so in any case, that request that PHG caused the surgery center to stop making the payments, that still doesn't comply with the statute because it doesn't lead to PHG suing in its own right. So then when we get to it, it's a second enumerated issue. PHG should seek a declaratory judgment that MMRG is not entitled to those payments. And these are, I think there were some questions previously, maybe from Judge Swan as well, as to whether there was standing. And it's our position that PHG could not sue MMRG because the contract was between Surgery Center and MMRG.
But they could have, if things were done correctly or at least differently, PHG could sue derivatively if it chose to.
Yeah, and I kind of worked through the math on that over this weekend. I'm not sure that I ever did it before because it's not part of the demand. But what would this look like? I suppose it would look like Barnett making demand on Rosenberg and Perkins to cause PHG to make demand on BDPEC, and if BDPEC refuses, PHG would then sue BDPEC for breach of the duty arising out of the operating agreement for the surgery center.
Yes.
All right. I worked through that this weekend, and I think that's the way it was supposed to look. But if there was going to be a valid demand, but that's not the demand that was made here. So moving on to the refusal, there's the December 19 response letter to Barnet's demand that I was just talking about. And the response letter was 7 pages, I believe, and it didn't refuse Dr. Barnett's demand. This was 2 members, and I know there's been, or managers, there are also members, and I know there's been discussion that Perkins and Rosenberg didn't have anything to lose here, but that's not true. The way this thing is set up, it's like other medical practices. You have the active income. So you have the young doctors over here, not necessarily young by age, maybe they don't have as much business, whatever the situation is. They're active doctors. They're at BDPEC, and they're being rewarded for the money, or for the business that they're bringing in and the money they're making. Then you have the passive money being paid over here at PHG, because you have Delaney, you have Barnett, who's not working actively anymore. You have the older doctors. Dr. Perkins' name is on the door, so he's over here. They had set this up as far back, I think I was reading this, 1999, but it's been around a long time. And the intent was that it was going to provide retirement income for these guys. It had a value to them. And so when you look at the December 19 letter, what you're reading is not that there's some conspiracy, but rather you're reading that Perkins and Rosenberg are going to try to save this whole thing, both sides of it. The younger doctors who are wanting to be compensated more, and they're also wanting to save, of course, their own interest in PHG. So there wasn't a refusal, and to the contrary.
Well, Counsel, I thought a lot when I was preparing for this case. I've thought a lot about the argument that you're making. And when Dr. Barnett says, I want you to cause PHG to sue, if in a response letter, if they don't agree to sue, I don't know how that can be anything other than refusal, because what happens next? So they say, well, why don't we do A, B, and C instead of suing? And then what's Dr. Barnett supposed to do? Right back to say, no, I really want you to sue. I'm not agreeing to A, B, and C. Then that means that the statute doesn't require one demand, it requires at least 2.
And I understand your question, certainly. This isn't a situation where someone's making an offer and there's a counteroffer, and we all know when there's a counteroffer, it's a refusal of the initial offer. These are 3 managers who are discussing under the statutes how best to proceed. There's been a demand made. And so for the manager making that demand, it's important to get out to that person the thoughts of the other 2 people. There's no evidence, there's nothing that indicates time was of an essence here, that they couldn't have taken 1 more week to talk about this. So there was the demand, and
well, I'm asking this sincerely. How long does Dr. Barnett have to wait before inaction becomes a refusal?
Well, statutes always drive us crazy like this, but the statute we're talking about, 29-831, says after a refusal or after adequate time to consider the demand. So it could have been, what's adequate time? That's something that's going to be considered on a case-by-case basis.
But it seems like Dr. Barnett thought 2 days was adequate, because he sued on the 3rd day, correct?
Yeah, it was the 21st. Dr. Barnett caused the lawsuit to be filed without responding to any of the comments or anything else in the December 19 letter.
Was he required to respond?
There had not been a refusal in the way I'm reading the letters. So if there was no refusal, 2 days without any time pressure, I would think that's as a matter of law, not an adequate amount of time before filing the lawsuit.
I feel as though we may be spending a lot of time unnecessarily on the mechanics of the derivative case as it relates to your client. There's a direct claim.
There's a direct claim that's not proper because it's the implied covenant of good faith and fair dealing. And what this claim is an attempt to do an end run around two aspects of a derivative claim. First, if people...
Wait, let's assume there was no derivative claim. Let's assume that the derivative claim was properly dismissed. You've still got these pesky direct claims that we should probably talk about.
Okay. The implied covenant claim is not a proper direct claim. It is based on the exact same factual arguments as the derivative claim. And so it should have been brought as a derivative claim. And here's the problem when you bring an implied covenant claim as a direct claim. No longer do you need to have a demand. All of a sudden the demand requirement, the refusal, all of that's put to the side. You don't have to make demand. And when you have a PHG operating agreement, section 5.4, that has the duty of care as gross negligence, all of a sudden you can just bring your implied covenant claim and say, well, maybe it's not gross negligence. Maybe there's more of an affirmative obligation for you to act in good faith. So that direct claim is nothing more than an attempt to cover up those two aspects of a derivative claim because it's based on a harm that goes to PHG. It goes to all of the members to varying degrees of PHG. It applies to Perkins, it applies to Rosenberg, it applies to Dr. Pinkert, and it applied to Dr. Delaney at the time. So it should have been brought as a derivative claim.
Why can't a direct claim simply allege facts that meet the requisite standard under the organizational documents? Why can't Dr. Barnett sue the other managers directly, personally, and say, you committed gross negligence? You acted purposely to deprive me of the benefit of the bargain, and you did so in a way that can't even be salvaged by the business judgment rule. It meets the standard under the agreement. Whether that's true or not, structurally, that seems to work.
Yeah, but that's why there's derivative claims, because the derivative claims are to remedy a harm that's to the entire entity. So that's why you don't bring one director sues another director saying...
Well, where does it say you can't?
I
mean, that's a nice purpose of derivative claims, I agree, but why can't you bring both, as Dr. Barnett did here? That way, if one isn't successful, you've got the other.
Well, then there's no longer the gross negligence standard, and there's no longer... Why would... Because then it's just an implied... Get rid of the entire derivative claim and keep the implied covenant claim. Then it's just a claim of breach of the implied covenant of good faith and fair dealing. I don't have to make demands. So why would anybody go through that process?
The demand process?
Yeah.
I was wondering that myself. I think Mr. Schenck may have been as well.
And the way I'm reading...
But is it because there's no direct injury? There's only an indirect injury to PHG. So that's why a direct claim would fail, because the plaintiff isn't personally injured. Only the entity which he has an interest in is injured.
Yes, and that's what I'm saying, that it's the claim that belongs to the entity. I do want to point out, because of this questioning, I got 6 seconds. Would you indulge me for another about 17? I can point to a statute that shows how the implied... It's the partnership statute, and it doesn't apply to this case because it's a different legal standard, but it's 291034, and that sets forth the duty of care among partners, and it says loyalty and due care, and then it defines due care as gross negligence, and then it says as a separate provision, a party's duty of care to the partnership, other partners needs to be consistent with the implied covenant of good faith and fair dealing. So what this statute is saying, at least the legislature thinks, you take the implied covenant, you put it into the agreement, and it's part of the duty of care. That's what I've been saying. Thank you. Or I hope I have been. I appreciate you indulging me a few extra seconds.
Thank you.
And I ask that you affirm judgment in favor of my clients. Thank you.
Thank you.
Your Honor, first of all, I want to clear up one thing, if I haven't done so already, and the suggestion that anyone was harmed by the actions of the appellees other than Dr. Barnett is patently false, and certainly it is not true to the point where you could affirm a summary judgment on that issue.
Well, let's break it down a little bit, though. If there were different memberships in the different entities, some people may not have been harmed as badly as Dr. Barnett, but weren't some people benefited to a greater extent than others?
Now, I can assure you that every single other member of PHG other than Dr. Barnett either benefited from these transactions that are the subject of this lawsuit or were not harmed by them because they got as much on the MMRG BDPEC side as they lost on the PHG side.
Perhaps for the major players, but what about the members who's without management responsibility?
All right, well, there's only two of them that exist. First of all, in PHG, there are only 5 members. Dr. Barnett being one, Dr. Delaney being another who's dead. You have Mark Rosenberg, you have Perkins, and you have Dr. Pinkert.
How many members in BDPEC?
I think last I knew was 10. I don't know the answer to that.
And so those 10 members have interests that are at least, if not adverse, at least different than the members of other entities.
Well, there's no question that people who are not parties to this lawsuit benefited financially from the taking of the surgery center revenue. But that's not really an issue because they had an interest in BDPEC, which benefited from these transactions, but they didn't have one in PHG, so they didn't lose anything by the shift of income from PHG to BDPEC.
But that's only true to some of the members, not one of the members.
Sorry?
The fact that the shifting of funds that only benefited some, not all of the members of the other entities.
Well, we don't really know how they divided up the cash once they got it in their hands, but I'm saying if you just look at it mathematically, as I said before, Mark Rosenberg had a 10% interest in PHG, but he had a 10% interest in MMRG. Dr. Perkins had a 9% interest in PHG, but he had a 10% interest in BDPEC, which had a 90% interest in MMRG, 9%. So it was a wash for him. Dr. Pinkert had less than a 8%, I think he had like an 8% interest or less. So he actually benefited because he had a 10% interest in BDPEC. So he actually profited from the shift. And the last person that was a member of PHG that wasn't Dr. Barnett is Dr. Delaney. And in 2012, BDPEC went to Dr. Delaney and got him to sign a deal where they paid him his distributions directly from BDPEC in exchange for him relinquishing his claim to getting any distributions from PHG. Basically, he assigned his right to get PHG distributions to BDPEC in exchange for this payment. So they bought off the one other independent party in Dr. Delaney, and so at the end of the day, the only person who came out a net loser by all of these transactions was Dr. Barnett. No question. Now, as far as the direct claims, I got 50 seconds, so all I can say is you've got a provision in the operating agreement, a PHG operating agreement, that specifically provides for fiduciary duties by the managers. So Drs. Perkins and Rosenberg owed a fiduciary duty by contract under the operating agreement to Dr. Barnett. And so he has a direct claim for breach of that fiduciary duty. And we can quibble about whether he's, will have the evidence to meet the standard. And it basically said that it would cover cases of fraud, deceit, gross negligence, reckless, or intentional misconduct. We allege that what they did was intentional misconduct, and we have the duty to prove that, but clearly if it was intentional misconduct, it meets the standard for breaching that fiduciary duty provision in the operating agreement. Similarly, with regard to the bad faith, we were direct parties. Dr. Barnett was a direct party of the operating agreement, PHG operating agreement, with Mr. Rosenberg and Dr. Perkins. And they surely deprived him of the, not only a major benefit of his bargain, his principal, his only benefit from the bargain, namely the right to receive regular distributions from the surgery center.
Thank you, counsel. We appreciate your arguments today. We'll take this matter under advisement and issue a decision in due course. We stand adjourned.